and I hear it sometimes
Oh,
on the American media that the Supreme Court is striking down laws because they're not reasonable. This is just not true.
Dr. Lurie, recently, just back in April, you published the following study, quote, Appointment of Judges to High Courts in Democratic Countries, a Comparative Study. What is this research about?
Well, it's really a response to the government's attempt to reform or change the manner in which judges are appointed in Israel. And one of the ideas that the government had was that the coalition should have decisive voice in the matter, should have the deciding vote on whether judges to all courts, both the Supreme Court and the rest of the lower courts, the coalition will have the deciding voice. It will decide and will control basically the appointment to all courts. And one of the arguments...
By coalition, you mean the majority in the Knesset, right?
Right, the government and the majority, which is based on the majority in the Knesset.
Okay.
And one of their arguments was that that is the way in which judges are appointed around the world, and Israel is unique in its appointment process, or really in its selection process, which involves professionals and doesn't give the decisive vote to government. And so what we wanted to do in the study that I made with Professor Amichai Cohen was to really fact check whether this is in fact the case. And what we found is that it is not the case. In fact, looking at particularly at Supreme Courts or constitutional courts and democracies, we found that usually, almost exclusively, the coalition cannot appoint or select by itself the judges to the Supreme Court. And there are various measures that try to check the power of the executive in appointing Supreme Court judges, whether it's an institutional separation, as you have in the U.S. Supreme Court, where the president nominates and the Senate needs to approve the nomination, or if there's a supermajority that selects in the parliament, or there are various measures that try to check the power of the executive or the majority in the parliament in the appointment process. And in fact, if the coalition in Israel would have been successful, it would have made the Israeli selection process very unique in that sense in democracies.
So let me see if I get this right. In the U.S., the president appoints a Supreme Court justice. Then it has to go through a process of confirmation in the Senate. If the Senate is of the same party as the U.S. president, then that makes the job easier. But what you have in Israel is that the governing coalition of perhaps several different parties in the Knesset, and it's not a bicameral system. You don't have another legislative body. It's not like Senate and House of Representatives here in the U.S. So the ruling coalition wants to be in a position that it selects a Supreme Court justice, since Israel's president comes from that same coalition. There's essentially no check on this selection, right? I mean,
yes, the prime minister is really the head.
I'm sorry, that's what I meant to say. Prime minister, yes, like Mr. Netanyahu, yes.
There's no check, and really, if you look at it even from a more wider point of view, it's not only the Supreme Court. It's once the government decides
all the courts
will have the power to control the selection, will do so in all courts of the land. It's not a federal system. There are no different states or different executives or different court systems. It's just the one single
central government,
statewide court system, and the government wants to have control over the appointments to all the judges in all the courts of the land, without any check on its power.
Before the current moment and the controversies and conflicts that are going on in Israel because of this attempt by Mr. Netanyahu to overhaul the judiciary, was the selection, and in this case, it's professional selection going back, of Supreme Court judges, was it a politically hot button issue like it is here in the US? Every time we have a new Supreme Court, politics, everyone gets riled up. And rightfully so. I mean, you can see what happened to abortion, right, after Mr. Trump's appointments. So has it been a political issue in Israel?
Well, it's a process in which it's become more and more important issue, let's say, and in terms of the public view of it. But also from the first years of Israel, there was a sense that there, particularly in terms of diversity, there was interest in what will happen in Supreme Court selections, and in terms of Sephardic Jews going into the Mizrahi Jews going into the Supreme Court of Israel. There was a lack of that in terms of diversity from Jews, and that even from the 1950s, you can see that type of public concern. But really, since the 1990s, I think with the Supreme Court coming into the public eye and becoming a lot more prominent in terms of the Israeli politics, the judicial selection has also become a lot more important in the eyes of the public and in the eyes of the political system.
When you say 1990s, the Israel Supreme Court becomes more prominent, are you referring to what is called the constitutional revolution of the early 1990s, correct? Dr. Fuchs is also shaking his head in confirmation. Okay. I've come across this thing that's really interesting as an attorney. It's just interesting to me. In the law, we have many different standards of judicial review. The public hardly knows about it, and most practicing attorneys don't often even know about it. They're just going about their day, more concerned with discovery matters than really the standards of judicial review. But all of a sudden, the reasonable standard of Israel's Supreme Court, a judicial review standard, is all over the news. Gentlemen, what's going on with this?
Well, you should ask that Mr. Levine and the government. I agree that this shouldn't be on
and he's the
news.
Minister of Justice?
Yes.
Yeah.
I agree with you totally. It shouldn't be on the news. It shouldn't be such an issue that every person in the street is talking about. Although it's nice for us as law experts that we became so popular and everyone are interested in our work.
Yeah. So what is that standard, the reasonable standard?
Yeah. Well, first of all, you have to understand that this is only an administrative law, and there are some people who confuse it with constitutional law, and I hear it sometimes on the American media that the Supreme Court is striking down laws because they're not reasonable. This is just not true. The Supreme Court strike down laws, and it happened only 23 times since the 1990s, since the new basic laws of 1992. Only if they are unconstitutional, they are against a specific right or paragraph in a basic law, which define the basic law, the basic rights of it's like a Bill of Rights in Israel, but this is constitutional law. They won't change that too. They tried on February and March to have an override, and they tried to change the power of the court to have
by they you mean Mr. Netanyahu and his coalition, that's a majority. Yeah.
They tried, and for now they failed, but they didn't say they won't do it again. But for now they put it aside, and what they did do now and succeeded is abolishing the reasonable standard towards the government and the ministers, and this is just administrative law, not legislation. When the government, as a full body, is decides on something, having decisions, or the government, the ministers themselves, then the Supreme Court has power to have administrative review, and they do have other grounds, for example, conflict of interest, or if, for example, some grounds of how do we say it? General justice, something like that. But the standard of reasonableness it's like a default. When you see a really irrational decision, you don't know why, you don't know what was the motive there, what was the conflict of interest, why did the government decide that irrational decision? Sometimes, and it's kind of rare, but it does happen, the Supreme Court said this is unreasonable and this decision must go. For example, what we fear, and in a way the ministers say it in recent time, the current government, they say they want to fire our Attorney General. And to explain the role of our Attorney General, this is a big issue, but just to she's the chief legal advisor, and also she's the senior prosecutor. See, she's the chief of the prosecution of Israel. And one small detail here is our prime minister is under indictment of bribery. He is the chief prosecutor.
Small detail, tiny little detail,
and
yeah.
The government, and they all talk about it, they want to fire her, okay? And they didn't do so because they know that if the government will fire the prosecutor, who is now prosecuting the prime minister, it is 100% that the Supreme Court will say this is unreasonable. And one of the motives here is to take away the power of the Supreme Court to say about these kind of decisions of appointing someone or firing someone, these kind of decision, that they will not have the power to say that this is unreasonable. And since last week, we don't have anymore
so this has an immediate impact on Mr. Netanyahu. Let me play devil's advocate here. Let's say the Knesset passes a law about the Dead Sea, about the Jordan River, just environmental law, no political stuff, just environmental law. And then the Supreme Court, Israel's Supreme Court, reviews it and says, no, this is unreasonable. If that happened in the U.S., to some extent, that would be an issue, because that law would have to be vague, or would have to be counter to prior laws, or would have to have other issues for it to be struck down or be unconstitutional. What I'm trying, where I was going, and I think you go ahead, please. I think you see where I'm going. Go ahead.
Yeah, but again, you cannot say about a law that the Knesset passed that it's unreasonableness. It's not.
That's why you were saying administrative?
Yeah, it's only on administrative decisions of the government or the ministers. So Knesset legislation, just like the Supreme, just like the United States, they have to say that this is counter to a basic law, which is our quasi-constitution. So this is not related to constitutional review, only to administrative review of decisions of the executive, the government, or the ministers.
I see. That's interesting. We'll be back after short.
Ask me kind of a similar question, which is, okay, the government, which was elected, is deciding something, some policy in a government decision, not in the Knesset. This is a fair question, and
like an executive order by the U.S. president.
Yeah, very some big policy, which it's not in a law; it's a decision of the government. And I have to agree in a way that, and we had some very important experts in Israel that had some critic over how the Supreme Court used its powers over the years. And so even now, there were a lot more mild suggestions that, for example, only if it's on policy, not on nominations and firing the Attorney General or the Chief of Staff and all that, if it's just a decision of the government about general policy, if they would limit just that, the opposition in a way would have supported it, maybe in some kind of a compromise. And even, for example, after Levine proposed his general overhaul, there was a compromise suggestion by the president at around February. And there was also a solution to the issue of the reasonableness, and it was balanced. Of course, it was part of a big compromise on all the other issues about the constitutional review and about entrenching our basic laws that can be changed so easily by a 61 majority. So we can argue about that, but it's not what they're doing. They totally abolished it at all. And regarding everything, not regarding just general policy, regarding even, as I said, things that are totally irrational and unreasonable.
That's interesting. So those opposing Mr. Netanyahu's judicial overhaul and especially the changing of this reasonable standard, they would have compromised on the court's ability to use this standard on policy matters coming from the executive. And we can draw a line between policy matters versus pure administrative stuff, such as you give an example, firing the attorney general. That's really interesting.
Also, decisions that directly use with specific issues on specific people, not general policy. When it's general policy, I don't say that everyone agrees to limit the reasonableness. Some say what we have, we should keep it. But if we had a big compromise of all these constitutional issues and administrative issues, we could have agreed on that.
But you do realize, gentlemen, that that's not how the reasonable standard by Mr. Netanyahu's government is being shared on the news. It's a
we know.
Yeah, that's the news. We'll talk about background and history. We'll be back after a short break to talk about Israel's constitution.